Section 5 of Civil Law Act 1956, revised in 1972, is a guideline on applicability of English law in Malaysia's commercial matters. The commercial matters mentioned in Section 5 are law of partnership, cooperation, banks and banking, principals and agents, carrier by air, land and sea, marine insurance, average life and fire insurance, and with respect to mercantile law generally. The applicability of English law in Malaysia are different in Peninsular Malaysia except Malacca and Penang. Any issues that have relation with the stated subject is bound to the law that existed when the Civil Law Act was taken into force on 7 April 1956. While for Sabah, Sarawak, Penang, and Malacca, the law that should be administered is by referring to the same law in the same case happened in England at the corresponding period. The applicability of English law in commercial matters in Malaysia brings out several opinions among scholars. Any litigation related to the commercial dispute in Malaysia legal system should be judged according to the sake of the right of the innocent. Therefore, it is important to know whether the English law can be enforced in the context of commercial dispute by referring to the Section 5 Civil Law Act 1956, revised 1972. According to the Section 3 Civil Law Act 1956, English law is the common law of England and the rules of equity. It means it is a combination of body of rules developed by all common law courts in England, such as Court of Exchequer, and body of rules developed by Lord Chancellor in England, which were developed again by the Old Court of Chancery. However, the common law is not only documented with the rules made by the old common law courts. The common law also consists of custom common in every corner of England, some unwritten law and also precedents in the court. Although the rules of equity are not independent or cannot exist on their own like the common law, it was made to fill out any gaps or defects in the common law. The common law was introduced to complete the legal system in Malaysia as a step towards Malaysian independence from European colonization. Based on the subsection 3, paragraph 2, it can be said that this law was only applicable as the circumstances of the states of Malaysia and their respective inhabitants permits and subjected to such qualification as local circumstances render necessary. With the acceptance of the principles by the Malaysia legal system, the common law then officially became a part of Malaysia law until this day.
The Section 5 Civil Law Act 1956, which is revised in 1972, provides for the application of English law in Malaysia for West Malaysia in commercial matters. Commerce and trade has been the economic focal point of the British since their first settlement in the Prince of Wales Island, which is known as Penang today. To regulate those commercial matters and trade, a provision was incorporated into the enactment of Civil Law Ordinance 1878. Under Section 6, special application of English legislation is provided for the mercantile matter, which marked the formal reception of English law. Not only such provision remain, the essence of which also became the basis of Section 5 Civil Law Act 1956, which necessarily sets out the law to be applied in issues concerning partnerships, corporations, banks and banking, principal and agents, marine insurance, average life and fire insurance. For example, a case that happened in West Malaysia that has English law applied, which is Syarikat Batusina Sendera Berhad and AMP versus ORS and UMBC. This case concerned ownership claims over a second-hand tractor. The problem of double financing arose because the first purchaser, which is UMBC Finance, ownership was not endorsed on the registration card of the vehicle. Therefore, The High Court allowed the plaintiff's application where failure to register an ownership claim on the registration card would be caused the buyer not knowing the status of the vehicle. All buyers of second-hand vehicle in West Malaysia always depended on the absence registered a green light. This application also will constitute that the decision in English cases on failure to have an ownership claim should be not allowed. This case held in England that there is no statutory provision or facilities dealing with registration and licensing of vehicles for registration and endorsement of claim to ownership. Instead, arrangements are made among the finance company themselves. However, in Malaysia, we have the Road Traffic Ordinance 1958 in regard to registration of ownership claims, and therefore it is not necessarily to rely on English cases.
Assalamualaikum warahmatullahi wabarakatuh. My name is Afika Hassan and my metric number is 061853. I'm from Group 10 and my part is to speak about the application of English law in East Malaysia. East Malaysia is Sabah and Sarawak. Section 5 of the Civil Law Act 1956 provide the application of English law in East Malaysia, that is Sabah and Sarawak, in commercial matters. Sarawak received the application of English law in 1928 when the Law of Sarawak Ordinance provided the statutory authority on the source of law applied to the courts. Meanwhile, as for Not Borneo, which is Sabah, English law took place in 1938. The provision in Sabah are similar to Sarawak Ordinance, but the modification to English law by the local customary law were limited. For example of a case for this application of English law in East Malaysia, which is Sabah and Sarawak, a case that has happened in East Malaysia that applied to English law is the Loh Hok Ji v Melbourne Finance Berhad case. This case concerned the purchasing of a car, which is Mercedes-Benz, using a public tender for RM1,100. The tender has transacted at one of the branch offices the defendant in Kota Kinabalu, Sabah and Mir Sarawak. The car was then handed over to the plaintiff after he gave full payment for it, but the car since problem arose when it was in charge of seizure due to the susceptibility for forfeiture. The plaintiff claimed a refund for it due to the failure to consider the circumstances of the car. However, the defendant has shown no consideration for it. The primary issue in this case is to whether the principle of nemo dat qui no habet was applied or not to the defendant. Therefore, the judge has stated that the defendant has not been discharged from the burden of proof to avail itself due to three reasons, which is: firstly, the Malaysian Sale of Goods Act 1957 cannot be applied to Sabah and Sarawak, which is East Malaysia. Second, a reference has to be made to Section 12 of the United Kingdom Sale of Goods Act 1957. Third, the defendant has failed to submit sufficient evidence to support its averment. That's all from me. Thank you.
There have been a lot of opinion regarding this matter, and a lot of scholars have been doing this study for every aspect. Professor Ahmad Ibrahim was one of the most outspoken supporters of repealing Section 5 of the Civil Law Act of 1956. He affirmed that instead of English common law, Malaysian courts should look for local law within Malaysian legislation and court decision, which would necessarily privilege local situation and people, especially regarding the case of lacuna. Lacuna in terms of law do bring a meaning of non-liquid. In short, non-liquid is any scenario or case in which there is no relevant law. A lot of Malaysian scholars agree with Professor Ahmad Ibrahim's opinion. They believe that what is required is not a totally replacement of the Civil Law Act 1956 or a comprehensive reform of the existing system, but rather a change in the approach of judges, counsel, and academic scholars. These scholars believe that the judges in particular should take a more active role in indigenizing English law. To achieve this, the Civil Law Act of 1965 might have to altered to allow courts to refer to sources other than English, such as Malaysian religions and customs. However, Malaysian scholars who have been even more critical of Malaysia's reliance on English law and have urged the Civil Law Act 1956 to be repealed completely. For example, Sheikh Ahmad Al-Sagaf argued that it is past time to repeal the Civil Law Act 1956, freeing Malaysia from the last legacy of colonial authority. The Civil Law Act of 1956 may have fulfilled its function in presenting Malaysia with English common law and equity in its early post-independence years. However, times have changed. It is horrid and demoralizing that any time a new situation comes before Malaysian courts that is not covered by written law. As from another side of the scholar's opinion is the Malaysian Bar Council strongly oppose any departure from common law, whether through a repeal or abolition of Section 5 or the Act as a whole. The Bar Council claimed that the use of English common law in Malaysia should be considered as a strength rather than a disadvantage. It conveys security, confidence to Malaysian investors and enterprises. The Bar Council claimed that Malaysia's connection to common law through Section 5 does not restrict Malaysian courts from establishing Malaysian common law. English cases admitted by Malaysian courts are generally incorporated into Malaysian common law. In reality, throughout the past few decades, Malaysian courts have been documented in Malaysian law reports, which then serve as precedent for future cases. At the same time, the court has the authority to reject any English law that, in its judgment, is not in condition and people. The Federal Constitution has officially recognized common law as part of Malaysian law. Thank you. That's it from me.
In conclusion, English law can be applied in Malaysia according to Section 3, 5 and 6 Civil Law Act 1956, subject to three requirements, which is absence of local legislation or statute covering the same matter, cut off dates, and suited to local circumstances. English law may suit extremely well in its country, however, being foreign, it is not essentially translate well in native or local environment. Therefore, it is important to implement the three requirements so that it can be suited for the local circumstance. Validity and necessity of applying English law can be examined further. Therefore, there is no doubt that English law can play a major part in our nation's legal system right up until independence. As a fledgling independent nation, it was important to hold on to the laws of the land that we were used to.